right now. It's the only thing that saved you from going to jail. I had pretty much made up my mind that when I came back out here because of what you had done, you were gone.
Well, yeah, I can tell. I really can tell. Because if you're trying to fire this guy, yeah, you got a problem.
Pause right here. This is a huge judicial moment. The judge is basically saying you were one breath away from jail. That person standing next to the defendant, that's legal protection in human form. Judges rarely admit they've already decided on jail time. When they do, it's a warning shot. Question for you, do you think the judge already crossed the line mentally, or was this a fair reality check?
Mr. Mellinger? Why what has to be so direct?
Why my answers have to be so direct. But yes, I am waiving my right for a preliminary.
You know what? You better check your attitude with me.
Answering your question, sir.
You can go back. I'll see him in a minute. Mr. Belvisi, check your client.
And just like that, contempt of court. 30 days, no trial, no jury. This isn't about guilt or innocence. It's about disrespecting courtroom authority. Judges use contempt to instantly regain control. Pro tip, arguing with the judge about your attitude is the fastest way to lose your freedom. Would you have stayed quiet here or tried to defend yourself?
Because not to... Oh, wow. Okay, bring it back here. You're in contempt. That's 30 days. You got anything else to say? Anything else you want to tell me?
You guys, you just like
anything
versus Chloe Whitsett.
Edward Drukas on behalf of Chloe Whitsett, who is approaching, Your Honor.
I'm sorry, Your Honor. I'm dismissing my court-appointed attorney and representing myself.
Okay, start with this. What's your name?
Chloe Whitsett.
Okay. And you're intending upon representing yourself in this matter?
At this time, yes, Your Honor, I am. I am dismissing the court-appointed attorney at this time, yes.
Okay, what's going on?
Until my family and I decide what law firm we are going to choose, I will be representing myself.
Okay, all right. So you need time to seek a attorney?
Well, not really, but I have a request at this time as I am representing myself.
Well, not until such time as I relieve Mr. Drukas.
Okay, thank you.
That's what I'm trying. I have not done so.
Okay.
So I'm trying to figure out what the issue is and what you're intending upon doing.
Dismissing the court-appointed attorney and representing myself.
Okay.
I'm sorry. At this time, I can't make it any clearer, and I don't understand.
You're not making it very clear to me at all.
Okay.
You're not listening.
I'm confused.
Just talking. Are you going to hire an attorney?
Yes.
Or are you going to represent yourself?
Today, Your Honor, I'm going to represent myself. If my request is denied by you, then I will be hiring an attorney. I can't make it any clearer than that.
This is where things get dangerous. Representing yourself sounds empowering until reality hits. Judges are required to warn defendants, but they will not babysit you. Leaning on the podium, talking over the court, these small behaviors signal big problems. Drop a comment. Would you ever trust yourself to handle felony charges alone?
So so if I relieve Mr. Drukas, you're going to represent yourself?
Yes, sir.
So if they set it for a preliminary examination, you're ready to go?
This is I'm representing myself today. I don't know what all happens today, but I'm talking to the judge without the court-appointed attorney.
No, ma'am.
Okay, well, I don't.
Don't listen. You don't you dare just lean on my podium and pretend like that. Not here. Okay, here's what I'm going to do. I'm going to pass the matter because if you come back up and start banging your nails on that podium, you're going to be going with Mr. Allen. You may have a seat. Don't shake your head at me. Oh. Mr. Allen, might want to have a conversation with her and tell her that she better check herself before she comes back up here. Thank you, Mr. Durkin. Okay, so who wants to go next? Christian Philippe.
Apologies on behalf of people.
And Edward Drukas on behalf of Chloe Whitsett.
Your name.
Lucinda.
Apologies on behalf of my client for earlier. I did have an opportunity to speak with her during that break and go over the process of where we are, what's going on right now. She did.
Notice the shift here. The attorney steps back in and immediately calms the room. That apology wasn't just polite, it was strategic damage control. Judges remember tone, posture, respect. This is courtroom chess, not checkers. Do you think the apology saved her, or was the judge already done?
Tell me that she would like to obtain a new attorney. So in the meantime, I can assist her with getting a copy of the discovery, getting a copy of the videos, which I don't have yet. I was going to be asking for an adjournment today to obtain those. So ultimately, I'd be asking for at least a 2-week adjournment. And I talked to her about her behavior in court, and I think that she has an understanding of that and will abide by anything the court orders her to do. So with that, I'd be asking for an adjournment of today's hearing.
Is all of that correct, Ms. Whitsett?
Your Honor, I would like to apologize. I had complete zero understanding. But yes, that is correct.
Ms. Whitsett, let me tell you something. I should have locked you up. You're lucky that I just took a deep breath and said, I don't know what's going on. I'm just asking her questions.
Judges have long memories. That's not drama, that's doctrine. Courtrooms run on credibility, and once you lose it, every future interaction is uphill. Next time she appears, no warnings, no patience, just consequences. Let me ask you, should judges give second chances like this, or does it invite more disrespect?
And you come in here, I don't think we've ever seen each other. And you just come in here disrespecting me in this court. And I'm going to tell you something else. That man standing beside you right now, it's the only thing that saved you from going to jail. I had pretty much made up my mind that when I came back out here because of what you had done, you were gone. So while you may not want him representing you, he just saved you. But remember one other thing. Funny thing about judges, we have exceedingly long memories. You come in here acting like that on the next day, I'm not even going to ask any questions. You are just going to go. Are we clear?
Yes, Your Honor.
April 11th, 2024, 9 a.m. as your invite indicates. It's time the defendant's bond will continue.
Thank you.
Here.
Again, I do apologize.
2024, 9 a.m. as your invite indicates. It's time the defendant's bond will continue.
Thank you.
Okay, what are we doing?
I invite my client to use the name in this one. I can go agree with the breakdown.
So what, you're willing to withdraw? Sir?
Sir.
What are you saying?
Not his client, sir. He's not, he's an ineffective assistance counsel. He's not representing to his fullest potential. That's what I believe, sir. Sorry, I was speaking out of turn.
Oh,
Apologize for that.
so who do you want to represent you?
Anybody but this guy.
Anybody but this guy?
Yeah,
Why?
because I mean, sir, I mean, can I speak?
Sure.
I've been through the system a few times. I mean, I'm a lawyer. Obviously, I'm not a lawyer. I really don't know a lot, but I think that I've been represented enough times to know that somebody should represent me better than this guy. And when I come in and speaking to this guy, and he's talking to me like he's a prosecutor and he's supposed to be my lawyer, then yeah, we got a conflict of interest here. So I would really like to remove this guy from even helping me at all. I don't even want to speak to this guy whatsoever.
So he's speaking to you like he was a
Like,
prosecutor?
I'm just no, he's speaking to me like I'm like, yeah, like he's trying to fry me just like the prosecutor's trying to fry me. So I don't got no type of talking to this guy at all. I don't even want to speak to this guy. I didn't even need that at all. I don't got nothing to say to him. And then I try to explain myself, and he's like, it's just, yeah, it's not gonna work for me. It's not gonna work at all.
Oh,
And that's the best way I can describe it, sir.
it was pretty descriptive.
All right. All right. I appreciate you letting me speak.
You do realize that sometimes defense attorneys do that?
I do, but like I said, sir.
But hold on.
I mean, like I said, I'm not a
Sometimes
lawyer.
defense attorneys do that to challenge their client.
I don't want to defend
But not-
challenge me. I want somebody that's work with me, not challenge me.
Well, sometimes defense attorneys have to challenge you
All right, well,
because sometimes there are hard questions to answer, and he wants to prepare you as to how to answer. But you don't like that exercise because you want somebody that's just going to patsy you and just tell you everything's going to be okay.
Absolutely.
Okay, well, I don't know that they have those in that office.
I'm not looking for that. I'm not looking for that either.
So,
I'm just looking for somebody other than this guy.
so did you? Somebody other than this
Somebody
guy?
other than this guy. Yeah, that's it.
Yeah, he's one of the best attorneys out there, but that's okay. You don't want him. That's fine. That's your business. That's your business. It's not anybody's business. That's your business. So I don't know how to do this because he's just part of an office. So there's no withdrawal. Did you talk to anybody at the public defender's office about your concerns?
And this guy came to see me one time. I told him, man, you know what I'm saying? Pretty much I didn't want him to be my lawyer, and this is what they sent me in. So, I mean, I don't know what I'm supposed to do about it, sir, to be honest with you. Maybe you can help me out.
Help you out how?
Any way you can, besides having this guy represented.
Well, I don't run that office.
Okay, sir. I guess I have to go through the proper procedure then.
What a concept.
Yeah.
How long is that going to take you?
I don't know. I mean, every day is, every day I can kind of be in jail, so I guess it don't matter.
Oh, doesn't matter.
I mean, it does.
So I can put it out to wherever I want?
What's that? No.
Never mind. Okay, well,
Let's not do that now.
well,
Yeah.
see, that's what happens when you represent yourself.
I ain't trying to represent myself. I ain't touch mine.
Well, yeah, I can tell.
I ain't touch
I
mine.
really can tell because if you're trying to fire this guy, yeah, you got a problem. Mr. Mellinger?
I believe you might be able to get something assigned to him within a week. If we could have that.
So you want a week out?
I would appreciate
That's amazing. After the horrible things he tries to say about you that nobody else believes, just be quiet. That nobody believes, you're still advocating for him in terms of getting the shortest time. I got to give you credit, counsel. Because I would have asked for a date sometime in August. But I'm that vengeful. We'll turn it out 1 week and see if they can get somebody represented maybe to his satisfaction, maybe not.
much appreciated.
So I'll turn this out May 9th, 2024. (9 a.m.) And if they do reassign, and sir, so that you understand, they don't have to reassign. That office is there. You haven't really stated to me a conflict other than that you don't like the person. So that's not a conflict. Huh?
I don't know enough to like me. I just feel like he's not representing me like
I know. With your law degree, you made that decision. All right. Thank you. Bond will continue.
And here we go again, another defendant, same mistake. Tone, attitude, pushback. This is the exact moment where ego costs freedom. Waiving rights while challenging the judge is like playing poker while insulting the dealer. Spoiler alert, the house always wins. Would you have answered differently or kept it short and safe?
Courthouse case, People versus Vincent Lambert.
Your name, sir?
Vincent Lambert.
Thank you.
This time there's no offer for my client, so we request a waiver and seek an offer of service.
He's waiving his right to preliminary examination.
That's correct.
Is that right, sir? So you're waiving your right to a preliminary examination?
I guess so.
Well,
Yes, Your Honor.
you know what you're doing, sir?
Yes, I do. I don't know why my answer got to be so direct, but yes, I am.
Why what? Why what has to be so direct?
Why my answers have to be so direct, but yes, I am waiving my right for a preliminary.
You know what? You better check your attitude with me.
Answering your question, sir.
You can go back. I'll see him. I'll see him in a minute. Mr. Belvisi, check your client. Because not to. Oh, wow. Okay, bring him back here. You're in contempt. That's 30 days. You got anything else to say? Anything else you want to tell me?
You guys are just like.
Anything else you want to tell me?
Yes, I do.
What? You better watch your mouth because you're going to get another 30. You're going to get another 30. What else do you want to tell me?
Nothing at this time, Your Honor. I apologize.
Thank you. You are on your way out. We'll bring him back later, maybe. Hold those. Court does call the case People versus Thomas Styron. Your name, sir?
My name's Thomas Dyer.
All right. Mr. Styron, you still wish to represent yourself?